I'm Alex Neale, Senior Litigator at Devlin's Ottaway. We help businesses from small startups and entrepreneurs to large corporations who are in dispute or facing insolvency. This video is part of our Companies in Crisis series, which puts together the most common questions to help directors navigate through the pandemic and beyond. The question I have today is, my company is receiving more and more pressure from creditors, which the company cannot afford to pay. I believe that the company is insolvent. What options do I have? There are both formal and informal options that will be available to you. Firstly, on the informal options. The most common and the most common starting point is to try and agree an informal arrangement with your creditors. Normally this is where you try and lean on your business skills and developments over the years and have an honest conversation with your creditors as to the position you are faced, and try to agree at some form of stage payments going ahead that the company can afford to make. Secondly, you can of course seek external finance. This can come from a raft of different parties, most commonly banks. However, I do appreciate this may be a struggle if the company is insolvent. Further, you can think about a sale of some of the assets or the company itself. This is always an option available to the directors and the company to consider. Moving to the more formal processes, and this is where you get an insolvency practitioner involved. The first one is to liquidate the company. There's two ways of doing this. The first is a creditor's voluntary liquidation, where there is a resolution passed by the shareholders to place the company into liquidation. A insolvency practitioner will then be placed in as liquidator and will seek to realise the assets, look into claims on behalf of the company to try and dispute this amongst the creditors of the company. The next is compulsory liquidation. This is via a court order. There are various stakeholders that can place a company into compulsory liquidation. Firstly, being of course a creditor of the company, but the director himself can also place the company into compulsory liquidation. Again, a liquidator will be appointed and will seek to realise the assets of the company and consider other claims in order to maximise the return for creditors. Another option that is available to companies is administration. This is quite similar to liquidation, however, an administrator will be placed into office to try and either trade the company as a going concern and to try and realise assets as much as he can for the benefit of the creditors. Further option, although quite niche, is receivership. This is where a receiver is normally placed over a particular asset in order to take control of that asset and sell it for the best available price to maximise the return for creditors. Another option is a company voluntary arrangement. This is where an insolvency practitioner is engaged again prior to liquidation and will seek to put together a pack to present to creditors for their approval. This pack will normally include a provision that they will receive a lesser sum than they are due, and provided the correct amount of creditors do accept the proposals, this will be binding on all of the creditors and will be overseen by a insolvency practitioner. As always in this series of videos, it is paramount for directors to take advice as early as possible and as soon as they believe there may be issues or concerns in the future. The earlier you take advice, the more these options will be available to you and the company.